Good morning. Good morning, Mr. Ozin, Ms. McGibbon. Thank you very much indeed for sitting early today. I'm sorry if it's caused any inconvenience. We will be rising at 12:30. Mr. Ozin.
Lady, I appear for the Appellant, the Association of Chartered Certified Accountants, generally known as ACCA. The learned friends Mr. Hitchins and Ms. McGibbon appear for the respondent, Mr. Awodola, pro bono publico, instructed through advocate. As the court knows, both parties were in fact subject to the same representation at the High Court. So we all have that advantage, knowing what evidence was deployed before the High Court. This is an appeal by ACCA against the decision on the 17th of January of last year of Her Honour Judge Walden-Smith in the Administrative Court. Permission was granted on both of the appellant's grounds on the merits by the order of Lord Justice Warby on the 8th of March of this year. The permission decision is in your bundle. I don't think we need to go to it.
Well, if I could just say, you can assume that we've all read widely and we've read the materials that are in the bundles.
I'm most grateful. Milady, by way of brief introduction, we would say that the appeal concerns the proper construction of ACCA's bylaw for deciding which rules apply when there is a change in the procedural rules relating to an existing case. And as will be apparent to the court from the way in which we've sought to frame our appeal, but we have, that is to say, ACCA has brought this appeal because it considers that there are issues of great importance with far-reaching consequences in relation not only to its own cases, but also because the form of words are used in the rule in question widely by other regulators. We respectfully submit that, with the greatest of respect to the learned High Court judge, that she was not only wrong in her interpretation of the rule, but her construction has the effect of blunting the edge of a once sharp tool for identifying which rule applies in the circumstances that I've described, and thereby has the capacity to cause confusion and uncertainty. In particular, it would cause regulators to have to abide by outdated rules in old cases, all of which we respectfully submit is to the disadvantage of both regulators and the regulated.
Well, perhaps we can therefore go to the construction.
The lady, yes. May I invite the court to begin at the Royal Charter and bylaws, which the court will find in the authorities bundle at tab 2. Try, if I may, to just pick up a few of the more pertinent points.
And so we're at tab 2.
Milady, yes, tab 2, beginning at page 6. May I draw the court's attention to the introduction, which is a helpful starting point. it indicates that the Royal Charter is the constitution of the association. And there are a couple of points that we would seek to draw to the Court's attention. One is the primacy of the Charter and the bylaws over the regulations, which is articulated here at the bottom of the first paragraph. The Association's Council may from time to time make such regulations as it thinks fit, provided such regulations are not in any way inconsistent with any of the provisions of the Charter and bylaw. And in the second paragraph, point pray and aid, members are reminded that on applying for admission to membership, they sign an undertaking that if admitted, and as long as they are members, they will observe the Charter, bylaws, and regulations for the time being in force. And we respectfully submit that that is an important form of words because it's unambiguous. It says you look at the rules that are in force now, and that it is a general aid to the construction of all the provisions that apply within the Charter and the bylaw, and in particular the provision in question which is central to the determination of this appeal.
Well, it's no different from members of a company agreeing that when they buy their share, they will abide by the articles as they may be amended from time to time.
The Lord, yes, precisely. I don't think I can touch upon this, I think, fairly shortly. At paragraph 2b, page 8, the bylaws are the second schedule to the Charter. Page 15, paragraph...
Sorry, bylaws are the second schedule, yes, thank you.
Page 15, Article 16. This is the same point that the Lord touched upon. This is the articulation of the fact that the Charter gives effect to the principles stated in the introduction, that the regulations may be made and amended subject to the primacy of the Charter and the bylaws. And then may we draw the Court's attention to the final substantive paragraph, which we would respectfully submit as a general aid to the construction of the Charter and the bylaws. It indicates that our letters or the enrolment thereof, that being the letters patent, shall be in all things valid and effectual in law according to the true intent and meaning of the same, and shall be taken, construed and adjudged in the most favourable and beneficial sense, and for the best advantage of the association, as well in our courts of record as elsewhere, notwithstanding any non-recital, misrecital, uncertainty or imperfection in this our Charter. So we would respectfully submit that for the avoidance of doubt, supports a purposive and possibly even a strained construction in the interpretation of the Charter and the bylaws to avoid various adverse consequences, but in particular to avoid uncertainty or imperfection. Then, within the bylaws themselves, may I invite the Court to go to page 20 in the same tab. And for 7A, this is the articulation principle that we've already looked at. 7A, the Charter, bylaws and applicable regulations for the time being in force shall apply to each member on and following his admission.
You're at tab 20.
The lady, no, I'm in tab 2.
Thank you. I was just anxious because my tab 20 is blank. Yes, I'm in the right place now, and therefore I've got 7. Thank you.
I do apologise. So I was going to 7A, the Charter, bylaws and applicable regulations for the time being in force shall apply to each member on and following his admission, and insofar as the Charter, bylaws and such regulations provide, following his ceasing to be a member. In addition, the Charter, bylaws and applicable regulations shall similarly apply to each person who undertakes or agrees to be bound by them. So it gives the effect to the application of the rules in force for the time being. And again, the court has the point that we attach significance to that unambiguous formed wording. Then, taking the matter, I hope, rather more briefly, over the page, Article 8 is entitled Liability to Disciplinary Action, and it sets out the various heads of liability for disciplinary action, a familiar list to the court comprising such matters as misconduct, incompetence, breach of bylaws or regulations, and then other specific matters including relevant adjudications. Article 9 then goes on to set out the rules relating to the disciplinary process, and may I draw to the court's attention that in the first sentence it indicates it is the source for the power to make regulations concerning procedures concerning disciplinary proceedings, including those relating to appeals. So it is the source for the power to make regulations relating not only to the substantive proceedings but also to the appeals. And more specifically, if the court turns over the page to page 23, the non-exhaustive list for the subject matter of such regulations includes at letter B the procedures to be followed by each committee, and at letter G the circumstances in which appeals against a disciplinary order may be brought and the procedures for dealing with such appeals. Then to complete the tour, the court will note at Article 11, under the title Application and Interpretation, the stem indicates that it relates to bylaws 8 to 10, which shall be interpreted as follows, and the provision with which we are concerned, C, for the avoidance of doubt, a person shall be liable to disciplinary action. So pausing there, that is the subject matter of Regulation 8 that we just looked at. In accordance with the bylaws and regulations in force at the time the matters complained of took place. All disciplinary proceedings, however, shall, for the avoidance of doubt, be conducted in accordance with the bylaws and regulations in force at the time of such proceedings. One point to note, we would respectfully submit, is that the bifurcation, if I can call it that, contemplated by that provision appears to separate out liability to disciplinary action on the one hand, and then everything else which is categorised as procedural matters. So insofar as it is necessary to determine whether a particular matter is procedural or substantive, the court may think that that is a useful aid to the construction of that issue.
What do you say, what has introduced the doubt that is there mentioned in paragraph in bylaw 11C?
Well, my Lord will have seen the way that we put it, that we say that this alludes to what everyone would automatically assume is the position in any event.
Surely what it's actually talking about is, if you look at 11B, 11B talks about a former member, former relevant firm and former registered student shall continue to be liable to disciplinary action, etc. So in other words, this isn't just dealing with present members, it's dealing with past members. That might give rise to some doubt as to how you proceed against a former member. So, quote, for the avoidance of doubt, you know, because that phrase is normally used where something that's just been said might be thought to create a doubt.
Yes.
And so, for the avoidance of doubt, a person shall be liable to disciplinary action in accordance with the bylaws and regulations in force at the time the matters complained of took place. In other words, what it's saying is, if after you've ceased to be a member, you are proceeded against in relation to matters that took place when you were a member, for the avoidance of doubt, you're proceeded against in accordance with the bylaws and regulations in force at the time. But, again, for the avoidance of doubt, the manner in which the proceedings are going to be conducted are conducted in accordance with the current bylaws and regulations. I mean, so that's what it's actually dealing with, isn't it? Otherwise, what's for the avoidance of doubt bit?
Well, one construction, which is the one that we've advanced, is that it relates to the first head or the first sentence in the same paragraph. But I accept the Lord's point that it relates to any question of doubt that may arise as to which procedural rules apply, and that doubt may arise where, as my Lord indicates, one proceeds against a former member. It may arise in circumstances that we've alluded to in our written submissions where the rules change over time.
Well, I have substantial reservations about the second proposition, given that it appears to be dealing with something for the avoidance of doubt. And the one thing that's certainly not, the two things that are mentioned in A and B are all to do with, as it were, people who are not, whether or not you're a member of a firm, number one, at the time of the occurrence, and two, whether you're a member of the organisation when the proceedings are taken against you. I've struggled with the idea that the drafter had in mind the possibility of the change of regulations in the course of disciplinary proceedings, and then chose to deal with it in that oblique way, prefaced by the words for the avoidance of doubt.
Yes, one might note that the paragraph itself also begins with the words for the avoidance of doubt. So there are two doubts alluded to, or potential doubts.
I agree. I mean, both, but caused, it seemed more obvious to me, by the provisions of A and B, which indicate this is a regulatory body, that it isn't limited to disciplinary proceedings being taken against its current members for things, because otherwise somebody could very easily evade disciplinary action by simply resigning membership, for example.
I don't, with respect, disagree with my Lord's analysis, but nor with respect do I abandon the submission that I originally advanced in our written submissions, because it may be thought that the application of the liability to disciplinary action in accordance with the bylaws and regulations in force at the time the matters complained of took place, may also give rise to an inference that you should look to the same time for the purposes of the procedural rules that apply.
But what it could be, see, when it talks about the bylaws and in accordance with the bylaws and regulations enforced at the time of such proceedings, its primary meaning seems to be to say it's you conduct the process in accordance with the bylaws and regulations in force at the time the proceedings commence and continue, rather than those rules which were in force when the person was a member and did the thing of which complaint is now made. So it's really, I struggle to see that it's really thinking about a change in the rules during the course of proceedings, using that word neutrally.
Yes. I would make tentatively a general observation, which is that although these provisions have been drafted with very considerable care, and indeed, so far as the bylaws are concerned, they require approval by the Privy Council, as the court will appreciate. It may not be appropriate to construe them in quite the same way as a statute.
I agree with that.
Mm-hmm.
I agree with that.
And so questions of the draftsman's intent need to be approached with a degree of care.
Yeah, no, it's the words for the avoidance of doubt always set an alarm bell ringing, because it generally means you've got to look to see why the draftsman thinks there's some doubt about the provision. And as I say, it seems to me that the doubt is potentially caused by what's gone before, which is normal. And everybody I know has focused enormous attention on these words because they're the only words that seem to have any bearing upon an issue or an analogous issue as to how to deal with timing in relation to disciplinary proceedings. Anyway, there we go.
But before we do, also, I'm interested to know what you say about the use of however in the third line of 11C. Does that, in fact, support my Lord's construction? Because it is suggesting a looking back at the first part of 11C, and therefore those parts are conjoined, or would you put a different slant on the use of however there?
Lady, I would say in assessing the competing claims, if I can call them that, the Lord's helpful addition to the discussion and our original position, I would respectfully submit that the word however is neutral. It plainly looks back, but the question is, what does it look back to? It could look back
Just to the sentence before, or could look back further than that.
That's precisely the point. And one might say that the more natural inference is that it looks back
Just
to
to
what
the
has just been
sentence
said
Yep.
in the previous sentence.
And
So-
if you take that analogy back, then the first sentence goes back again to what's just been said in 11B, if you see what I mean.
Mm-hmm.
Yeah, I was going to go on, if I may, to the appeal regulations in question. It may be that I can take this rather shorter, because the court has indicated it's done extensive pre-reading. It has the point that the rules changed. I don't think I need to take you to the specific rules. I can give you the references if that would assist.
Just remind me how it happens. There's an internal decision to change the rules, and that decision comes into force and is announced for the first time on the website
Yes.
on the day it comes into force.
That is correct.
Yep.
But I would add this, milady, that there is an established practice going back, so far as I can tell, for many, many, many years that there is a whole new rulebook promulgated on the 1st of January of a new year.
If I telephoned on the 31st of December and asked whether anything was going to happen the next day, what would I be told? Come back tomorrow, or it's Happy New Year.
Given that it's New Year's Eve.
Yes.
Go away.
Well, let's say the 18th of December or something.
Let's try the 30th of November.
Yes.
Yeah.
Well, I suspect if the matter is dealt with properly as one would expect it to be, all members would be reminded of their undertaking when they became a member to abide by the rules that are in force at any given time.
Yeah.
And they would be reminded that there would be a new rule book that is issued on the 1st of January, because there always is an entire new rule book.
But would they be able to find out what it is?
I dare say they wouldn't, because it would be published for the first time on the 1st of January.
Just remind me in the bundle, where's the letter that was sent to Mr.
For the
Awodola?
supplementary, isn't it?
Yes.
So the question that I rudely heard hurled across the court, would Pamela Ramphal, the hearings officer, have known on the 30th of November what the rule changes were likely to be?
I think the answer is I doubt it, although it's possible. She would have known that the rules are liable to change, and indeed it may be sensible in future if all such letters contain a paragraph giving that qualification. But what I would say about that letter is that both she and the recipient should take it that anything said is subject to the possibility of the rules changing.
So you can't rely on anything the hearings officer tells you?
You can rely upon it as representing the current state of affairs, subject to the implied qualification.
There's no implied qualification, is there? I mean, there's just, it's absolutely unequivocal.
But it makes all questions from the office worthless from about the 30th of November, because the recipient doesn't know what the changes will be, nor will you say, the case officer, or however she describes hearings officer. And so the letter, in fact, is of no assistance to anyone.
I mean, this is actually the hearings officer who has responsibility under the regulations for administering the regulations, doesn't she?
Yes.
How many hearings officers are there? Yes, please. 4.
4.
Thank you. So it's quite a small team.
I think it varies from time to time.
Of course, but roughly, I wanted to know whether it was sort of, under 10 or 100.
Are they consulted about rule changes?
Will all be answered no. But the court just give me a moment to see if I can expand on that. By way of amplification, my understanding is that the hearings officers are not legally qualified, although they are plainly able and experienced officers. And although they would not ordinarily be consulted in relation to rule changes and proposed rule changes, it would be within their power to seek assistance from others who were aware of such contemplated rule changes.
And Mr. Ridd, on the 30th of November 2018, as chairman, would he be aware of the forthcoming changes? How many chairmen are there?
I understand at present there are 5 or 6 chair people.
Yes, quite right, Mr. Quite right. Thank you. And they're accountants or lawyers? Or
They
both?
vary. Mr. Ridd, from recollection, is an experienced lawyer, certainly one of the more experienced chairs. And they do vary. Yes, some of them are accountants.
So we've got Mr. Ridd and Mr. Wilson.
Yes, Mr. Wilson is an accountant. Again, a very experienced chair.
And they would be presumably consulted on forthcoming changes.
Doubt it.
Milady, I think the best answer is not necessarily. They may be.
Thank you. And there's always a legal advisor, isn't there? So we can see that from Mr. Wilson's decision. And we know that he took advice from Mr. Mark Ruffle, as he says so.
Yes.
And not so in relation to Mr. Ridd's decision, where there's no mention of a legal advisor. Does the appeal... Anyway, what about the legal advisors? Are they aware of who makes these changes? Which people make the changes?
It would be an internal department and also at a managerial level within ACCA.
So not involving the legal advisors, not involving the hearings officers, and not involving the chair necessarily.
Well, again, I'll take instructions if I may in a moment.
Yes,
but certainly my
digressing.
understanding is that what occurs is that when issues of concern are identified in the run-up to the issuing of the new rulebook, consideration is given as to whether it is appropriate to make amendments to the existing rules. But I'll see if I can.
I appreciate there's no evidence on this, and it may not be directly relevant, but
Lady, I'm told that there is a standards department within ACCA that has responsibility for considering matters of this kind. And it would ordinarily consult with the council, which is made up of accountants, and there may be some additional consultation, but ordinarily it is not the conventional course that hearings officers or chairs of tribunals are consulted.
thank you.
Lady, with that background, I was proposing to go on to my ground one.
Mm-hmm.
Well, just so that we've got the facts, if you're not going to take us... Sorry, I think you said you were going to go through the regulations and the changes. Let's just get the timing right.
Yes.
The letter comes out on the 30th of November saying to Mr. Awodola that he has 28 days to submit his request for reconsideration by the Appeal Committee by the 2nd of January, yes?
Yes.
And he submits his request on the 2nd of January, and he's told, no, the rules changed yesterday. It now goes to the single chairman on paper. Yes?
Yes.
And your submission is that rule change took effect on the 1st of January, therefore, second, there's no longer recourse to the Appeal Committee. It's like a guillotine. I think you said at the start it's a sharp tool that comes down, yes? So if we look at the appeal regulations that were in force when in 2018. And you look at, it's page 90, A90, I think, tab 5.
Yes.
Yeah. And the relevant, as I understand it, the relevant regulation is regulation 6, sub 3,
Yes.
G. This was what was in force, which was referred to in the letter of the 30th of November. If the chairman refuses permission to appeal, the appellant may request his application notice be reconsidered by the appeal committee in accordance with regulation 6.4. Such request must be filed with the hearings officer within 28 days after service of the chairman's written reasons. Yes?
Yes.
So the change then that's made on the 1st of January, you can see at page A112, yes?
Lord, yes.
And it's again 3G. In all other cases where the chairman has refused permission to appeal, I'm reading little 2, in whole or in part, the appellant may request his application notice be reconsidered by a second chairman in accordance with regulation 6.4. Such request must be filed with the hearing officers within 21 days
Yes.
after service. So why didn't the chairman just simply say, sorry, you're out of time, if your logic is correct?
Well, the cutting down of the time limit would not have come into effect.
Yes, it would.
Yes.
Because the logic is, in accordance with 6.4, if you look at 6.4 over the page, in the event that a request complying with regulation 6G3(2) above is filed, the application notice shall be reconsidered by the chairman on the papers in private without a hearing. Why didn't the chairman just say, sorry, as of yesterday, I had no request complying with regulation 6.3G2 because it wasn't within 21 days. Sorry, you're out of time. That's the logic.
Well, conceivably, it was.
Well, the logic,
Yes.
I think everybody could understand the outrage that would arise if that were the view taken.
Yes.
But the logic of your submission is that that's what should have happened.
Well, subject to overriding considerations of fairness.
Oh, well.
Well. Now, where did fairness come in? Because isn't that what this interpretation is actually all about? It's about moving the goalposts in the middle of a disciplinary process, using that expression neutrally, when Mr. Awodola has been given a notice that, provided he requests a reconsideration by an appeal committee by the 2nd of January, that's what he's entitled to. How do you distinguish between the two situations I've just put to you?
By applying the criteria that have been developed by the court for the assessment of questions of fairness in relation to retrospectivity. And so, taking the Lord's argument, it may be that those within ACCA took the view that it would be plainly, manifestly unfair retrospectively to cut down the time limit. And so perhaps there was a bit of self-editing that took place at that point. In my respectful submission, that would be in accordance with the principles developed by the court, by the courts in the case law, whereas changes to the procedural rules that apply are not caught in the same way.
It's a change to a procedural rule. They're both changes to procedural
They
rules.
are.
You're saying there's a qualitative difference because, well, aren't you really saying just on the facts, because the effect would be so dramatic you would have no right of appeal altogether at all, whereas this was what change that you relied on as a tweak.
Yes. And to pick up on the lady's point, it would be cutting down a time limit plainly goes against all the instincts of a lawyer, because someone is told they've got 28 days, and then the rule changes, and they're told, well, I'm sorry, retrospectively, you didn't have 28 days, you only had 21 days. And it expired before we even changed the rules.
Mr. Awodola was also told he had a right of appeal to the appeal committee.
I accept that. I accept that.
And so what is the, I think you've said already, but just so I understand what you're saying, so what is the qualitative difference between, well, I can understand what the different outcomes are, but between the time limit and the destination of the appeal? What is the qualitative difference?
The qualitative difference is that although both affect what might be regarded as accrued rights, the rights in question have a different quality, and the level of interference with them also has a different quality.
But this really drives a cart and horse with respect through your arguments about certainty, because nothing about this is certain. If every time there's some sort of a change, you have to carry out a qualitative assessment as to its nature and effect and decide which side of the line you might or might not fall. Everybody else in this court might think that a right of appeal to an appeal committee is significantly better for the member than another bite at the written cherry.
My answer to that, lady, is that there would be certainty as to which rule applies. But if a regulator chooses to apply it in a way that causes manifest unfairness, it would be subject to the intervention of the court.
Well, hang on. This is all about the I thought we were here to interpret the bylaws.
Yes.
How can it be unfair? So, if you've got to interpret the bylaws. If the bylaws are what the bylaws are, your first submission was everybody's bound by them.
Yes.
And if everybody's bound by them, how is it unfair? It's not a question of application; it's a question of interpretation. How do you suddenly load some sort of notional fairness onto the top of it? Surely, the point comes in at the question at the interpretative stage.
Well, if a regulator...
How do we interpret the change and how the change operates?
If a regulator brings in regulations which, given the effect that we contend bylaw 11C has, applies in a way which causes manifest unfairness, then the regulator's new regulations are liable to be scrutinised by the courts.
Yeah, through the lens of interpretation. No?
You talk about judicial review.
I'm talking about judicial review,
Yeah.
yes.
So I'm looking at it in the way you started, which was you were emphasising to us the importance of the charter and the bylaws and the regulations, and there was not a sniff of judicial review at that stage. This was all about interpretation.
Yes. That is for the purpose of ascertaining what rule applies. And in my respectful submission, the subject to, obviously, the discretion to avoid the harsh consequences of its own regulations.
What you mean, that the association doesn't need to abide by its own regulations?
Well, the association should not impose regulations which, given our interpretation of bylaw 11C, would result in manifest unfairness.
Sorry. So you're saying we interpret the charter and the bylaws and the regulations as to their natural and ordinary meaning on the page. We get 11C and we interpret it in the way that you suggest. So we get the change, which is on page 112, which cuts down the time and the direction of the further reconsideration. And all of that, you say, is all flowing in one direction, because of the natural and ordinary meaning of those words. But then you're imposing separately a standard which says, but if the effect of all of that and the right to do this, and it's being done, is unfair, then either the member or ex-member has to seek judicial review, or alternatively, the powers that be decide on an ad hoc basis not to enforce. That is what you're saying?
Melody, that is the effect of it, yes.
So in fact, the rule change is followed by some ad hoc process if it's going to be unfair.
Well, ideally, one shouldn't introduce new rules that create unfairness given the effect of bylaw 11C. So they should be crafted in a way that does not cause unfairness.
I mean, this was blatantly unfair, speaking for myself, given the terms of the letter of the, in particular, of the terms of the letter. So if that's right, Mr. Awodola should be JRing. Is that right? That's what you're saying?
If that is right, yes. And
do you say its effect is not unfair?
I see the force, of course. I have to recognise it, of Milady's
But I mean, I could be completely wrong, and others may disagree with me.
No.
But I mean, do you contend that the effect was fair on Mr. Awodola?
I contend that so far as the letter is concerned, it stated a position which then subsequently changed. And if our contention as to the proper interpretation of the bylaw is correct, as I said at the outset, it would be better, at the very least, to say in the letter, what I say is subject to potential change in the event that the rules hereafter provide for a different procedure. You are reminded of your obligation to abide by the rules in force for the time being, which you will find on this link, for example.
Did the association abide by the rules for the time being in force in relation to other matters? Let's just change the facts for a second. Assume Mr. Awodola had lodged his application in the middle of December, straight away, within time. So under the 2018 regulations, he has a right to go to an appeal committee. Let's assume papers are sent to the appeal committee. What happens on the 1st of January? Does that all just stop? I mean, what about hearings that were actually going on in front of appeal committees on the 1st of January 2019? What happened with those? Did they just all stop? Did they just say, oh, sorry, we've wasted a lot of time, now we go to a hearing officer? Now it has to go on the papers to a chairman. What actually happened?
Well, my understanding is, in answer to your Lordship's questions, I'm not quite sure how it cut across other particular cases. It may be that I can assist the court in a moment. But if you had a right and you'd exercised it prior to the 1st of January, then that right is not retrospectively cut back. One just moves on to the position that applies in relation.
Didn't Mr. Awodola have a right prior to the 1st of January to serve a notice by the specified date and to go to an appeal committee? What's
Yes.
the difference? Why does he lose that, but other people who'd served the notice prior to the 1st of January continue with it?
Because the need for certainty occasionally results in harsh consequences for individuals.
Well, didn't he have an accrued right as of the 30th of November 2018 to continue his process, the process available to him then?
Subject to changes in the rules.
No, that's not an accrued right. That would be a right subject to change, but I'm suggesting he had an accrued right.
I understand the distinction. I'm grateful for that clarification. It wasn't accrued in the sense that it survives a change in the rules. That is my submission.
Well, in which case, what about the person who's halfway through an appeal committee hearing? Why would that survive the rules? What's the difference? What's this clear and logical difference that you contend that your interpretation provides?
The strict answer is that the rules in force at the time prevail, and if that results in an ongoing hearing being subject to new procedural rules, then the tribunal would apply the new rules.
So if I'm mid-evidence and on overnight the rules are changed saying, sorry, mid-oral evidence, no longer any oral evidence, you stop the procedure?
But
If the
it
rules
is a
say,
deliberately
If the
harsh-
rules suddenly say we're not having any oral evidence anymore, it's all going to be paper-based.
Yes. The lady gives a deliberate
An extreme example.
extreme example.
I'm sorry to be unhelpful, but it's
no,
a way of
it's not.
testing.
Strictly speaking, yes.
Really?
But the answer is, of course, you wouldn't change the rules in that way, and if you did, you wouldn't, as a matter of practice, in all probability, apply it to the ongoing proceedings by way of a pragmatic concession.
By way of, I was going to think that you were going to say you draft it better so it wouldn't happen. I think that's what you were saying. But you were saying if you hadn't, it would be another ad hoc sticking plaster.
There is a...
well, instead of the ad hoc sticking plaster, why don't we just go back to what you said is at the start of the Royal Charter, which is Her Majesty's request, amongst other things, that the courts might interpret the Charter and presumably everything under it in a way that you said needed to be purposive, if not, I can't remember, what was the expression I wrote down? Purposive, if not even strained.
Yes.
So to avoid these points, why don't we do this through interpretation?
Well, the court could.
Judge Blow did.
There is a balancing exercise to be struck. If one approaches the matter in the way that we have sought to develop our arguments, the consequences are of the kind that the court has pointed to in the past quarter of an hour or so. But on the other side of the scale, if you don't have a clear rule for identifying which set of rules apply, you end up with enormous uncertainty.
But the interpretation that you're proposing leaves uncertainty in the other direction because it depends on which sticking plaster the association decides to apply. Or not.
Well, as I've said, I don't disagree that if one formulates an extreme example of a new rule that could be introduced in that way, and one doesn't take account of the sticking plaster principle as it's been described by the court, you end up with...
Sorry, we haven't been formulating a particularly extreme example. We're actually been looking at the two changes you did make. One was to say you can't have an appeal committee reconsidering at all. It's got to go on paper. So there was a question about, suppose there is an oral hearing in front of because one of the other things that Mr. Awodola was told or the rules said he could ask for was an oral hearing in front of the appeal committee. That was a change I didn't bother to draw your attention to. But he had a right to ask for an oral hearing.
He had the right to an oral hearing before the full committee.
Reconsideration.
Which is what he wanted. That's what he wanted.
Yeah.
Yes.
So that was that was. So it's all the issues we've been discussing is not exactly an extreme example.
it's really about the meaning of the words, isn't it, at the time of such proceedings in 11C.
I mean, the appeal process is governed by separate regulations, as we saw, indeed, in your introduction. The charter, the bylaws make separate reference to the disciplinary action leading to a disciplinary order as defined, and then an appeal from the disciplinary order. One possible approach, not the one the judge adopted, I understand, but one possible approach is to look at the situation that appertained from the disciplinary order being made. In other words, when the appeal regulations come into force. One thing I'd like some assistance on from you is whether that is an alternative interpretation which doesn't involve the judge's solution of going back to the very start of disciplinary proceedings or the disciplinary action, but looks at the position from the point in time at which the appeal regulations, which were changed, come into play. In other words, if that point has been reached, that a disciplinary order has been made and the appeal regulations start to operate, would there be sufficient certainty if the appeal regulations which start to operate at that point in time are the ones that continue to apply? In other words, so you fix it by reference to the date of the disciplinary order, which is the point in time at which the appeal regulations which were changed come into play. I'll leave that with you as a question. Judge's solution was to interpret the word proceedings more broadly, to go back to the start of the action. And I raised that question with you,
Yes.
and indeed with others in the court as well.
My Lord, I think, certainly as I read the judge's approach, she alluded to what might be described as the whole shooting match, and said, well, on any basis, it doesn't make any difference, it's all in 2018, save for a possible referral in 2017, but nobody's mentioned that to me. That was her approach in her substantive judgment. In her permission to appeal judgment, she appears to have slightly modified the position with respect, and to have focused on the date of the initiation of the appeal. But the court has that point that we say, well, why pick any of those dates? And anyway, there is uncertainty as to what date applies in any particular case. More than that.
There's no uncertainty as to the date from which your appeal regulations apply.
No.
And that's booked because of 3.3.1 of the appeal regulations, is that right? Maybe looking at the wrong ones. I think I'm not. Tab 4 is the right to appeal arises upon being made the subject of a finding or order.
Yeah.
Yes.
Yeah. Actually, tab 4 is the one. Tab 4 is the one that was enforced the year before, isn't it?
Yes.
Tab 5 is the one that's in force during 2018.
Tab 5 is 2018.
And tab 6 is the one that's in force from the 1st of January 2019, I think. But it's
At that point.
my lady's right, that point doesn't change. It's 3.1, which says, is, well, when this framework kicks in.
Yes.
Or this part of the rulebook, I should say, these regulations kick in.
So the proceedings would, and I'm only speaking out loud, those proceedings would then be the proceedings under the appeal regulations in place at the time of the order.
think that was my Lord Justice Snowden's hypothesis. Yes.
Yeah, I
I'm
was
just
just,
trying
I
to
was
do
raising
the
it.
interpretive exercise of how you fit that into the wordings. It would be such proceedings means.
Yeah,
They are separate proceedings because they are an appeal.
yeah, and the other parts of the bylaws do deal separately, as we saw. So looking at the bylaws as a whole, we saw the bylaws, if you go back. Sorry, trying to find it. We showed us it. The disciplinary process bylaw 9
Yes.
talked separately about the proceedings leading to a disciplinary order, and then quotes in G, page A023, the circumstances in which appeals against a disciplinary order may be brought and the procedures for dealing with such appeals. So there does seem to be a recognition that there is something called, you know, a disciplinary process or disciplinary action, I think it is. Bylaw 8 talks about disciplinary action leading to a, quote, disciplinary order, and then an appeal against a disciplinary order. I mean, so there is some recognition of separate stages to the process, and indeed your regulations are separate.
Yes.
I raised it simply because, again, it doesn't seem to have had much consideration in anybody's submissions or thoughts. Again, we're being presented with an all or nothing. It's either proceedings from the very initiation of the disciplinary action on the one hand, or this razor that comes down every year on the 1st of January and just chops off, doesn't chop off appeals.
And in relation to which one doesn't know what one's rights will be after the guillotine, until the guillotine has struck the block.
It is certainly right that, unlike the approach taken by the learned High Court judge, my Lord's approach does identify, if I may respectfully say so, an ascertainable, clear point for the selection of the rules that apply.
Because thereafter there is simply one process. It's a process for consideration of an application for permission to appeal, however many times that is given or done. But it's a consideration of an application notice and then an appeal, if permission is granted. I mean, it is a continuum of, well, it's a continuum dealing with one document. I raise it because it's obvious why I've raised it.
Mr. Rosen, I think we've taken you away off course. I don't know whether you want a few moments to think about that, or whether you'd like to just go back onto your course, because time is elapsing.
Yes. Well, my lady, I'm just seeing whether I can pick up one point which may cut into, as it were, the Lord's fast ball, if I can call it that. And I suppose it is this point that the effect of my Lord's approach would be to put a check on the updating of regulations to take account of the modern conditions faced by the regulator. And we did set out in our skeleton argument, our first skeleton argument, at paragraph 15, the kind of disadvantages that would cause by reference to changes that have in fact been implemented by the regulator over time, such as the inclusion of a legal advisor, the fact that the registrant gets the last word on submissions, the fact that sanctions should be applied by taking the least serious sanction first. The ability to rescind a decision on the basis of new evidence that's come to light.
Well, but what it actually does, all this debate does, is point out that when changes are being made, when the black box produces the change on the 1st of January, however that black box functions, somebody within that black box ought to give a little bit more careful thought to how it's to be implemented by discussing with hearing officers or chairmen what effect it might have upon litigants within the system, as opposed to just a black box churning out with no or very little consultation. Something which is thought by some people divorced from the process to be a good thing.
Well, my lord, I don't, with respect, disagree with that, nor could I. But with respect, in a sense, it doesn't meet the point that I'm seeking to advance, which is if you do choose a point at which rights become accrued, to use Milady's word, referable to some finite point as opposed to just looking at what's in the rulebook now, there is an adverse effect, which is, strictly speaking, if you construe the rules, for example, if you bring in a rule that you don't need to serve papers in hard copy anymore, a rule that is of some significance in the context of ACCA's own work.
Well, except you can have a transitional provision that if it's thought to be in everybody's interest to have electronic service, you can have a specific transitional provision that makes it available henceforth, including in relation to prior proceedings. It's just somebody needs to do the thinking and actually put a transitional provision in place, as opposed to the one that you refer to us to. I know bylaw or regulation 24, I think, which is really not, speaking for myself, up to the job in the way I've just described. I mean, all the other examples you give in the skeleton of changes that have been made from time to time in procedure in the High Court, for example, or otherwise, are the product of some real thought as to how it might actually impact upon current proceedings. And that's what seems to be missing here. And so is the court, in essence, being asked to fill that void by way of an interpretation in this particular case? But we're not, it's not, this process doesn't exclude the possibility that for the future changes to the regulations, bylaws or otherwise might be made with some greater thought to the consequences.
I'm trying to think that through, if I may. The potential difficulty, I suppose, that it is if you are dealing with a legacy case, a case that goes back to 2015, before someone thought that modern times did not require you to serve 5 boxes of documents on a registrant. But subsequently you sought to cut down that right to paper copies by way of an express transitional provision, including a provision to the effect that it did have retrospective effect. The same argument potentially might run, but a person who was the subject matter of those proceedings in 2015 may say, well, I've got an accrued right. You can't cut down my right to paper copies. And you may well say that your provision has retrospective effect, but that's unfair. So I'm going to go to the High Court. So that is the trade-off that one has to make. And in our respectful submission, the rule that we submit should apply does have the virtue of complete clarity and the ability to modernise the regulators' governing rules, subject, of course, to the court's, well, subject to two things: the regulator not seeking to introduce rules that have an unfair effect, and if it does, the court's supervisory jurisdiction.
Thank you, Mr. Ozin. Perhaps we could let you go back to your course. I think you've perhaps, I don't know, made the submissions you want to make under your ground one.
Yes.
You may not have done, but please do complete those. We don't want to shut you out in any way.
No.
And then I think round two obviously turns on Regulation 24.
I'm going to try to set out the main planks of our submissions in what might be described as a skeletal form.
Okay.
The court will, of course, seen the further submissions that have been made in relation to ground number one in the supplemental skeletons. I've already touched upon how we seek to, as it were, update our position in the light of that. We thought that it was right, having stumbled across it in Halsbury's Laws of England, to draw to the court's attention specific cases on the cutting down of a right of appeal. Colonial Sugar and the Theo Conway case. And our position is that if you need to choose, it's Theo Conway, and Theo Conway is with us. But on a rather more holistic basis, both cases concerned a stronger right and a stronger form of interference. That is to say, the right to a substantive appeal, as opposed to the right to a second bite at an already arguably over-generous permission stage. And the cutting down of the right in question was in relation to the decision maker of a gatekeeper, a screener. And so we say different considerations apply. Then we say in any event, one has to take account of the superseding of that mechanistic approach by the approach adopted by Lord Mustill in the Loftus-Cheffinian case. And I've already addressed you on why I say it is not unfair in this case for there to be limited retrospective effect, because it is a proportionate cutting down for a legitimate purpose of an over-generous and burdensome procedure. So that's what we say in relation to the application of the modern approach.
I mean, that argument that cutting down the right of reconsideration from the full appeal committee to the single chairman is a proportionate response to an otherwise generous process is one that may be perfectly valid to make in a sort of a theoretical way, just where there's no individual in focus at the time. In other words, everybody may say, generally speaking, for the future, that's absolutely fine. You know, everybody should be happy with just 2 paper reconsiderations, no full oral hearing. The trouble is, this case relates to somebody who was in the process, whatever the process means.
Yes. I don't shy away from that. The best answer I can give is that occasionally, in order to have clarity, harsh consequences apply to individuals. But I don't shy away from the fact that Mr. Awodola was told he had this right, and then on the 1st of December he was told you no longer have it.
I didn't write down your answer to my lady's question about whether that you said that was fair or not. I'm not sure I quite got that answer. Right.
It was not so unfair as to be an unjustifiable step in the interests of a sharpened principle that works in other cases. And perhaps, with respect to the learned High Court judge, her approach was bedeviled by considering the particular circumstances of Mr. Awodola to the exclusion of how the rule applied in other cases, which...
But you can hardly be blamed for that. This is Mr. Awodola's application for judicial review.
Of course it is, but...
he's not here to sort of generally chew the fat about how the association treats its members.
I readily accept that, but on the other hand, if you're going to articulate a principle that applies to all the procedures adopted by the association, it has to bear in mind that it doesn't apply just to one case.
So,
I see.
The Lord has the point, though he may not like it.
well, no, I'm just wondering where it takes us. I mean, if you're right on your construction because it's good for the association more generally and its members, but its application in this case was unfair to Mr. Awodola, what do we do about the appeal in late? Because he is the person who did seek judicial review on grounds that it was unfair to him, inter alia.
Well, the Lord formulates a rhetorical question by including the premise that it is unfair to him. My position is it's unfortunate that that occurred in his case, but it is not so unfair as to be unjustifiable, even in his case.
How does that fit into the either framework of judicial review or the framework of interpretation of the Constitution? Where do you fit?
Well,
how does it fit?
the application to the facts may be a matter for debate, but the essential principle in my submission is clear, and it's clear on the authorities such as l'Office chef rien, in this sense that one doesn't legislate just for one case, one legislates for all cases in construing the provision in question and in considering the question of whether giving retrospective effect to the provision results in unfairness.
I mean, it's interesting, if one looks at the ground for which permission to apply was granted is hang on, that the defendant erred by not allowing the appeal committee to hear his appeal as stipulated in their appeal procedure, but instead applied new rules. So permission was granted on that and on a natural justice argument on the facts of this case.
Yes.
That's right, isn't it?
Yes.
So fairness is at the heart of it.
I do not shy away from that.
But you say, as I understand it, the rules should be interpreted as you suggest, strictly.
Yeah.
That's in favour of certainty and the proper administration on behalf of everyone.
Yes.
And the fact that it makes harsh cases in a few cases is tough.
Yes.
But it's not so unfair to be disproportionate, and that's the end of it.
Yes.
That's your case in a nutshell.
That is precisely my case. Yes.
Time is ticking, Mr. Ozin. Perhaps you just like to deal, therefore, I think, to the extent that you need to, unless there are more things that you need to say on ground one, with ground two and regulation 24.
Milady, yes. On ground one more point, if I may. Adopting the learned judge's approach, there would be, we respectfully submit, uncertainty as to which point to choose, and in fact there is no better an illustration of that than the approach that learned friends have been forced to adopt by developing their argument about what matters intuitively from the judge's approach is the date at which the proceedings were instigated, a phrase that one doesn't find anywhere within the regulations. In any event, that's a problem because you end up back in 2017, and consequently you have the possibility of 3 sets of rules, but in any event, it's not what the judge said. I think the court has that. So far as ground 2 is concerned, that turns upon the weight given, and the weight that should have been given, to the limited procedural savings provision in Regulation 24 of both sets of appeal regulations. And we would make this observation first. The terms of Regulation 24, I see the court turns to it.
Is that at 5/105?
I'm sure it is. It is. We would submit that at the very least it is inconsistent with the judge's construction. In this sense, she concluded that the whole of the 2018 Appeal Committee regulations were preserved, but they include the more limited express savings that wouldn't be required if she was right. And I have in mind in particular 24.2, the tests to be applied when considering whether permission to appeal should be granted shall be the test in force at the date of the application notice.
It's gone blank. What does 1 mean? Is that right?
The grounds of appeal, that is a reference to Regulation 5, which provides an exhaustive list of available grounds.
I see. Thank you.
And
So, thank you.
yes. But plainly, if the learned judge was right, you wouldn't need to, because you've got that in any event by virtue of the exercise, the construction exercise that she found applied. Now, of course, I have to take on board the point that I made at the outset, that the bylaws take primacy. So 11C will trump anything in the regulations insofar as there is an inconsistency. But the point that we make is that you cannot consider the question in a vacuum. 11C doesn't mean anything unless you apply it to a specific set of rules or regulation.
Sorry, I'm sorry. Maybe I just didn't follow that exchange with my lady, but 24.1 says the grounds of appeal shall be those in force at the date of the finding or order. And the grounds, did you say the grounds are those set out in Regulation 5?
Lord, I did in this set of regulations, obviously.
Right, yes.
Obviously, you go back to whichever set.
Yeah, okay, sorry.
5.2.
The date in question.
Yeah, so 5.2, the grounds.
Yes.
But then, so what did you say, 24.2, the test to be applied? That's just a reference to the test which is set out in Regulation 6, isn't it?
6A, yes.
Mm-hmm.
Well, it depends. There's a variety of tests depending upon, I think.
The Lord is right, but in this instance it is 6A because it applies to the Disciplinary Committee.
Right. So, but that's just, you grant permission to appeal if it would have a real prospect of success.
Yes.
On one of the grounds. Sorry, I'm struggling to understand why you say either of those two has any relevance to the question of where permission, sorry, the body that considers the application notice.
Well, if the learned judge was right, you put in an appeal, an application notice in 2018. At that point, you bank your entitlement to the 6A test by virtue of the principle applied by the judge, that is to say the interpretation of bylaw 11C, which means you don't need to have to state that again in 24.2.
No, you do.
Mm-hmm.
Because if you've started on the judge's finding, you start the proceedings in 2018. Let's say you lodge your appeal in 2019. What 24 says is it won't be the test in 2018 that applies, but it'll be the test in 2019 that applies. And without this provision on the judge's finding, that wouldn't be so.
Well, it depends which bit of the judge's finding one focuses on.
Right.
But if her
I thought she said
reformulation in her permission to appeal
right.
judgment is taken, the point is the point at which you apply to appeal, the point at which you initiate your appeal.
I've just lost that detail. I'm just looking at her permission to appeal.
Yes. This is like assist.
Thank you. It's tab 10.
Yeah. Could I invite Milady to look at paragraph 18 at page 81, and it's really the final sentence, I think. So at the bottom of page 80, this was a narrow point of construction of the defendant's regulations and bylaws as to whether the claimant's appeal of the decision of the Defendant's Disciplinary Committee was governed by the appeal regulations in force at the time the appeal was initiated, 2018 Rulebook, or at the time the application for reconsideration of the application for permission to appeal was submitted. So that appears to be the judge's last word on the subject, although I respectfully submit it's rather different to
You can't change your decision in
No,
your
you
permission to appeal judgment. So I'm looking at the main judgment.
Yes, I think it's paragraph 24
Yes.
or thereabouts in the main judgment.
It says the 2017 rulebook should apply. Right, appears. Suggest so. Right. The disciplinary hearings, the decision, and the application for permission to appeal all took place in 2018. So she goes for the 2018.
She does. And, Milady, in fairness, in our respectful submission, it's not really a fair point to make that no one has sought to suggest the 2017 rulebook applied. I certainly wouldn't do so because it was my case that you don't dip into the archive looking for the right rulebook. And no doubt the learned friends didn't suggest it because it was sufficient for their purposes to say that 2018 trumps 2019. But in any event, it appears to be a look at the whole shooting match. It looks as if it's all okay in this year. That's enough. For the purposes of Mr. Awodola's, as I've said in our respectful submission, he's not formulating a proper or sensible construction of the provision, bearing in mind its wide application.
I know we have intervened a great deal, but I do need to move you on because
No,
I've already been quite generous in the time that you've had.
Milady, I think I've come to the end of my submissions. There are, I can perhaps finish it in this sense.
Mm-hmm.
In relation to our ground number 2, we would respectfully submit you are entitled to take account of the provisions in the Charter and bylaw bylaws which emphasise the applicability of the rules for the time being in force and permit a purposive construction, with the points that I've already advanced. Lady, those are our submissions.
Thank you. Thank you. Thank you, Ms. McGibbon.
My lord, my ladies, I propose to address you on ground one, and then my learned friend Mr. Hitchens will address you on ground two, and also on some of the additional points in respect of the interpretation of the regulations themselves, which have arisen in the course of the hearing. We say, my ladies, my lords, we say, as the judge did, that ground one is very simple. In fact, no question of retrospectivity arises whatsoever. And the answer to this appeal lies entirely in the express, clear and obvious meaning of Bylaw 11C. My learned friend took you at the outset of his submissions to the introduction to the Constitution and made the point that members agree to be bound by the bylaws and regulations as they're enforced from time to time. Now, respectfully, we say that takes matters no further because, as we've already covered, the regulations are secondary to the bylaws. And so we have to look to the bylaws themselves to tell us which iteration of the regulations was in fact enforced at the time. And so we say the appeal turns, as the hearing in the High Court did, on the interpretation of the phrase such proceedings in the context of the provision all disciplinary proceedings shall, for the avoidance of doubt, be conducted in accordance with the bylaws and regulations in force at the time of such proceedings. I make 2 points in respect of the specific language used there. My Lord has to some extent already made them somewhat more eloquently than I'm sure that I will, but we say that the use of the language, however, and for the avoidance of doubt, between the first and second limbs of that bylaw has the simple effect of distinguishing between 2 points in time, 2 possible, or more than 2, indeed, possible points in time, and clarifies, to the extent that clarification is required, that the relevant point for the purposes of Bylaw 11C is the time of the disciplinary proceedings. Alternative points might be the time at which the matters complained of took place, which is the point referred to in the first limb of Bylaw 11C, or it might be, as my Lord pointed out, a prior time when a former member was a member of the association, as referred to in Bylaw 11B. And the second point is we say that the phrase for the avoidance of doubt simply reflects what one might expect as a matter of common sense to be the natural meaning of that phrase. One would expect that, as indeed Mr. Awodola did in this case, would expect as a matter of natural fairness that the procedure to be applied is the procedure which is enforced at the time of the proceedings. So we come back again to the question of what is meant by the term disciplinary proceedings. We say the judge was right to find that the proceedings took place entirely in 2018 in this case. But I take you at this point to our skeleton argument, our supplementary skeleton argument, and to paragraph 6. And we cover there some of the queries which my Lord raised, I believe, during the course of my learned friend's submissions. Now, we do say that the judge was right
Sorry,
to find...
which skeleton argument?
this is paragraph 6 of our supplementary skeleton argument.
appellant's
The respondents,
supplementary, respondent's supplementary, I think is at 20, and it says to be provided.
Yeah, I haven't got it.
I haven't got it.
I have got it.
ah,
Ah, okay.
I've received.
And as it happens, no, yes. Let me just make sure. Respondent, paragraph 6.
Thank you.
My lord, my lady, I apologise. I received an acknowledgement and
think
permission
it's
to
your
rely
fault.
upon it.
I don't think it's your fault.
Yeah, I don't think it's your fault.
The point is a simple one. I can take you through it orally. I suspect you may already have it. The point is simply that it matters not for the purposes of this appeal whether the proceedings referred to in 11C began in 2017 or in 2018, and if in 2018, at what point in 2018 they began. The 2017 regulations are material for the purposes that are material for this hearing, identical in terms of the right to a renewed oral hearing before the Disciplinary Committee. Now, the significance of the proceedings being instigated in 2018 is the fact that the papers for the proceedings were served on Mr. Awodola on the 2nd of January 2018, and that the significance of that point is that that is the date from which the charges against him can no longer be changed by the appellant, and it's also the date on which the appellant provided him with a copy of the procedural rules and told him that those were the rules by reference to which he should prepare his appeal.
No, not his appeal.
His
case, his defence.
His case, although the appeal rules were also provided.
Yes.
Now, I'll take you to that in the supplementary bundle because we say that is the start of the proceedings and the judges.
I mean, it may not matter to your client on the facts of this particular case
Yes.
whether proceedings means right from the start of the disciplinary action being taken, which you date to the 2nd of January 2018, or whether it's the start of the appeal time, which I think starts from the point in time at which the decision, the disciplinary order is made, which was the date in
It was November.
November.
November, my lord.
But it might make a big difference to the association which one of those two is right, for the reasons Mr. Rosen indicated, that there can often be a very long period of disciplinary proceedings spanning years. Ideally not, could do. And he says if you bring in all that, then you have a morass. And you have a less of a problem if you restrict it to the start of the appeal process. But he says actually what the association really wants, for clarity, is in essence 1st of January every year. I mean, that's really where the battle lines are, I think. So it may not matter for Mr. Awodola on whether the judge is right to go all the way back or some intermediate point. But it does generally matter in terms of interpretation of the...
I do accept it. It generally matters. I simply make the point that the 2017 regulations are materially identical.
Yeah.
The point perhaps is this. Taking the most generous view to the appellant, one might say that that one takes the point with the decision which is challenged, which is the refusal of permission to appeal. That is the letter which Mr. Awodola received, which explained that now he has 28 days.
That's still good enough for you. Yep.
30th of November is good enough for you.
I make the point that
And as you rightly say, tab 3 of the supplemental bundle confirms that on the 2nd of January, no doubt, deliberately, the day after the 1st of January 2018, the 2018 rules are sent to your client as part of the Notification of disciplinary hearing.
My lady has the point. We don't need to establish more than that. We don't need to establish, for the purposes of the appeal, that the right accrues any earlier than with the decision letter which refused permission to appeal. Whereas my learned friend has to advance the interpretation that such proceedings is a reference to each individual step in the proceedings, and so one applies the rules in force at the time of the step in question. Now, we say that cannot be a workable approach for a number of reasons, some of which my ladies and my lord have preempted. The procedure, as we've seen, is a logical sequence of events. It's not a series of isolated steps. It's a process in which each step is contingent on the last. And the court will not need me to make the point that effective compliance or failure to comply with one step in a procedure, a judicial or quasi-judicial procedure, has a knock-on effect on the remainder of the process. And so one simply can't cobble together a Frankenstein procedure comprised of different rules taken from different iterations of the regulations and expect to be left with a coherent process as a result. And to some extent my learned friend had to accept that, because this is a case where the period for the appeal had been shortened by the change, and so even on the appellant's case, there will be cases in which it's simply not possible to apply the rulebook wholesale as in force at the date of the decision. And my lord's already made the point that had Mr. Awodola applied shortly before the new year, by the time the matter came before the Disciplinary Committee, there would have been no provisions in the rulebook in force at that date, by reference to which the committee could have heard or dealt with the application. And so the committee certainly at that stage would have been forced to refer back to the 2018 rulebook. So we say that the appellant's approach is not quite the sharp tool which he has submitted to the court it might be. And this, we say, is important because a person who's engaged in the proceedings will, of course, look to the procedure and consider how best to conduct their case. And the ability to do that is an essential feature of procedural fairness. And that goes not just to the ability of the respondent to prepare his case and subsequently his appeal. It also applies to the appellant and to its officers. And Mr. Ridd, at the time of his refusal, would have understood that the appellant would have had an opportunity to renew his application orally. I appreciate he may have had some insight into the fact that the rules might change subsequently, but this was some months earlier, and there's nothing to suggest that he had any indication the right to an oral hearing would be removed during that period. And Mr. Ridd would entirely legitimately have taken that into account in considering when, how, and to what degree of scrutiny he should give the application. My lady raises her eyebrows. In support of that submission, I would take the court to the authority of EWHC, which is at tab 27 of the authorities bundle. Now, this is a case which concerns certification of applications as totally without merit, with the consequence that there will be no oral renewal, and the final decision will be the one which is made on the papers. I take the court to paragraph 17, which is at page 304. And the court considers there the approach which a judge will take when certifying a case as totally without merit, with the consequence that there will thereafter be no right to an oral hearing. And the court says at the end of subparagraph 3, the judge will only certify the application as totally without merit if satisfied in the circumstances that a hearing could not serve a purpose, and the claimant should get the benefit of any real doubt. Now, we say that would have, the fact that Mr. Reid would not have been the final word in this appeal would legitimately have affected the approach which he took in determining the application. My lord, my ladies, I don't propose to take you through the case law on retrospectivity, though my learned friend may do so to a limited extent. The points are set out in our supplementary skeleton, which I apologise profusely if you've not...
No, don't worry. As we say, I don't think it's your fault.
The point is, my lady, that none of these cases support the suggestion that a right to appeal can be retrospectively curtailed after the point which it has accrued. In fact, we say those cases either expressly or implicitly reject that proposition. Now, I don't propose to take you to colonial sugar, to take the court to colonial sugar, but there is a passage from that case which the court will no doubt have read in my learned friend's skeleton, in which the court expresses in strong terms that a right of appeal can't be removed or altered once proceedings are pending. And of course, in the present case, the proceedings were one step further, and this decision to appeal had in fact been notified. Similarly, in Theo Conway, that's a case where the decision which was being appealed against, it was an interlocutory order rather than a final decision in that case. But the order to be appealed against had not yet been notified or provided to the parties when the relevant legislation came into force. So it was not retrospective past the point at which the appeal right had accrued.
You said the difference here is the 30th of November letter.
Well, we say it's the decision of the tribunal because the decision of the tribunal was the decision to be appealed. In the alternative, it comes to the same thing if it was the 30th of November letter in practice, but the authorities indicate that it would be the substantive decision to be appealed. And one of these authorities to which I will take the court very quickly, if I may, is Nargis. Now, this is at tab 11, I believe. This is at tab 11 of the authorities under. And the court has the point already, I suspect, but this is authority for it. At page 195 of the bundle, at the top of that page, the court, in the context of considering at what point a right to appeal accrues, cites with approval this passage from Lord Bingham, which states in particular that a person cannot have accrued a right of appeal until he has a decision to appeal against, which he cannot do until he is notified of a decision. Now, my lord, this is page 195.
It's in the judgment of the Master of the Rolls, I think.
Indeed, yes it is. So the top of page 195. And the Master of the Rolls cites that with approval and says, the judgment of Lord Justice Bingham deals with the way I would approach the question of accrual accrued rights in this context. And so we say the right does accrue, the right to appeal does accrue on notification of the substantive decision which is to be appealed. And that's relevant also to my Lord's point that if perhaps the appeal is separate proceedings and such proceedings refers separately to the first instance trial and then the appeal is separate such proceedings. But we do say that the right to appeal accrued with the substantive judgment of the tribunal, and if we're wrong on that, then certainly it accrued when the first application for permission to appeal was refused on the papers in the letter that the court's already been taken to.
What I'm struggling with is there are two possible ways in which you say the association got it wrong. One is that on the interpretation of the bylaws, the regulation must be interpreted, or the change in regulation must be interpreted not to apply to Mr. Awodola's case, because as a matter of interpretation, you say that the proceeding was on foot from at least the point in time at which the original decision was made, against which an application notice was then filed for permission to appeal. There's a matter of interpretation, which is the way the judge primarily went at it. There's another way of looking at it, which we've sort of been considering in the course of this hearing, which is, if that's not as a matter of interpretation the way that it should be looked at, because Mr. Ozin is right that as a matter of interpretation you have a hard rule change. He then says, but the question then may arise as to whether it was, quote, unfair for the association to apply their rule change to Mr. Awodola, especially given the letter he sent. What I struggle with is how those two possibilities work as a matter of judicial review. Is this because this question of fairness that people seem to talk about as a matter of judicial review, fairness in the sense of taking away an accrued right, how is it unfair if Mr. Awodola has signed up to membership of an organisation which can change its rules, ex hypothesi, in that way? Why is it unfair to him?
My Lord, the way we put it is this. We say the 2018 rules applied because that is the effect of Bylaw 11C. If we're wrong on that, then the approach the court has to take is to apply the Interpretation Act, which my learned friend will address you on, and the case law to which Mr. Ozin has referred, to each of the procedural changes within the regulations themselves, and consider, by reference to those factors which are given by the House of Lords in the phosphates judgments, which include the extent of the retrospectivity, the degree of unfairness, the clarity of the language which is used to indicate that a retrospective effect is intended. One has to consider all of that, all of those factors, and apply them to the regulations themselves. So the approach that one would take would be to look at Regulation 6.3 and Regulation 6.4 and consider whether it's intended to have a retrospective effect, whether it's fair.
So you're sticking to interpretation, are you? You're not. You would still seek to argue the matter by reference to interpretation. I mean, Mr. Awodola very helpfully drafted his own grounds of appeal. If we look at the judgment to see what the ground of appeal, ground of application for judicial review granted was, it appears to be broader than a purely interpretative exercise, which I think is what my lord may be tilting at. And the ground is that he acted contrary to natural justice in applying a rule change. So assume against yourself for the moment that Mr. Rosen is right on interpretation. And the judge disposed of it on that basis alone. But can you go on to say, well, if that is right, then despite the fact that Mr. Awodola signed up to be a member, it is out with the reasonable expectation, that's the wrong word, of anybody signing up to the regulations to sign up on a basis that there could be unfair, unpublicised, retrospective changes, so that there is a breach of natural justice. So I think that's the question.
My lady, we do say that, and we did say that before the High Court.
Exactly, because we see that at paragraph 27 of
Yes.
the judgment.
And we say that the judge's comments on those points of procedural fairness and legitimate expectation were over to the extent that she made any comments at all. We did say in the High Court, my lady, that if it was correct that 11C has the effect for which the appellant contends it does, that is procedurally unfair. And in the High Court settlement, we also said it was in breach of a legitimate expectation on the part of Mr. Awodola, which had been created not just by the publication of the rules themselves, but also by this letter, which was sent to him by the hearings officer, which informed him that he had 28 days to exercise his right to seek an oral hearing.
You see, this is a clash between, or a potential clash between what I'd call company law, or the law of the constitution of an incorporated body, company law, and judicial review. It's not unknown, but it's a really difficult area because the principle of company law generally is if you sign up to become a member of a company, you understand that the articles can change, and there are specific mechanisms for challenging alterations of the article under the Companies Act, in the grounds that it would be unfairly prejudicial under Section 994 of the Companies Act, etc. And there's a body of law, a very big body of law, about the rights of members as members of companies. Judicial review is brought in from, as it were, left field because of the nature of the body, as I understand it, because it performs some form of public function. This is a regulatory, disciplinary body. But the concept of fairness as a matter, procedural fairness as a matter of judicial review is potentially very different from the concept of fairness as a matter of company law. That's what I was really probing at. Mr. Awodola is, in a sense, has understandably ridden both horses. He says, as a matter of construction of the Constitution, you can't do this to me. But if as a matter of construction of the Constitution you could, you've in fact done it in a way which is, quotes, procedurally unfair to me. And my question was really aimed at the point that how can it be procedurally unfair to you to change the articles if in fact as a member of the company that's what you've agreed to? And I mean, the judge didn't grapple with that because in fact the judge said she took the view that the interpretation was that the change didn't apply because the proceedings had started, were on foot. And therefore in paragraph 29 she said she doesn't need to deal with other submissions about, for example, fettering of discretion or interference with a legitimate expectation, which I'm just not sure, did she actually say this was procedurally unfair in a judicial review sense? I mean, she mentioned procedural unfairness at the end of paragraph 25, but that seems to be in the context of a interpretation of the articles, as of the bylaws. I'm just struggling to fit these submissions about unfairness and about removal of rights into a box that's either marked interpretation or marked judicial review. I mean, that's what I'm really struggling with conceptually. I don't know whether anybody else has got it clearer than me. I mean, how do you give me can you give me a structure?
I'll attempt to, my lord.
I think you'll find it in your skeleton below, at
Yes.
paragraphs 10 through
Well-
to 14, at tab 14, where you have not been granted permission to deal with legitimate expectation or fettering of discretion, but you've not been. And so, do you see page 123? And duty. And you still need to, I think, to answer my lord's question, but that's where you deal with it. You dealt with it below, anyway.
My lady, I'm very grateful for the bundle reference. My lord, that is at page 123, which is our skeleton before the High Court. And I think there are 3 points which I would make in answer to my lord's question.
And forgive me, just you've got the JR reference into Smith at footnote 3 as to how. Anyway, there we go. I'll keep going.
We do indeed have the reference to Smith at footnote 3, which is at page 11 of our skeleton argument. That's at page 124 of the core bundle, my lord.
But keep going. You were about to answer the question, and I interrupted.
My lord, the appellant is a public body, and so at no point has it been disputed that they are required to comply with the general principles of public law, of which procedural fairness is one. And that if they are to make a change to their rules, which it's accepted they're entitled to do, and if they are to make a change which has retrospective application, which, if we're wrong about 11C, we must accept that they're entitled to do, they're nevertheless bound as a public body by the same constraints that any other public body would be, to act in a way which has regard to procedural fairness, legitimate expectation, and these public law principles. And as I understood my learned friend, it was conceded to some extent that if the appellant introduced a rule which contravened those principles, and various examples, some real and some hypothetical, were suggested as to ways in which that might be done. If the appellant contravened those principles, then the remedy would be by way of judicial review. This is not a company; it is a public body, so there is no alternative challenge, alternative method by which one might challenge such a change to the rules. And so, if we're wrong about 11C, then we say those principles nevertheless apply. And this goes to the point we make about the distinction between the context of interpretation of statutory provisions, including statutory provisions which implement procedural changes retrospectively, and changes to the regulations, such as the regulations in this case. Parliamentary sovereignty, which is a theme which weighs heavily in all of these decisions, which are cited on statutory interpretation and the question of whether a procedural change which is implemented by statute is to have retrospective effect. The subject to all of that is that, of course, if Parliament expresses a sufficiently clear intention to make such a retrospective change, then it has the power to do so. Parliament is sovereign, and however unfairly one might be affected, or however egregious the breach of a legitimate expectation, that would be the effect which it has. Now, the appellant doesn't have sovereign powers in that respect and is bound by these principles of public law.
So, but what's the decision then that the court would strike down as a matter of judicial review? Is it you strike down the alteration of the regulations?
No.
Or is it you say that it was unfair for the association to apply their altered regulations to Mr. Awodola in the way that they did?
Well, in the first instance, my lord, we would say, as we did in the High Court, that the appellant maintains a discretion. Now, this is something which has been denied consistently, and in fact, legal advice was taken, and the appellant says it confirmed it had no discretion. Mr. Ridd had no discretion. Today we've heard for the first time that in fact there is a discretion, and that is why the 28-day rather than the 21-day time limits was
I had understood the judicial review to apply to the refusal to allow
Yes.
the appeal hearing. So there's no attempt to strike down the regulations as a whole on the basis of procedural fairness. It's limited to the decision on the facts of your case.
Well,
in that letter, as I understand it.
Right, yes. And when we say that could have been done on a discretionary basis, and so there's no need for us to challenge the...
More sticking plaster. Not just sticking plaster in relation to 28 or 21 days, but also in relation to route of appeal, in order to be procedurally fair in this case.
Quite, my lady.
If the regulations are construed against you.
And we see this from page 84, tab 11. The decision on the challenge for judicial review purposes is that of the 14th of February 2019.
Quite, my lady. Yes. So we did say that there was a discretion, and it appears the appellant now accepts that was the case, both in terms of the time limit that was applied and that the matter would have proceeded to an oral hearing under the old rules if Mr. Awodola had applied just a few days earlier. So the other point I made briefly in response to my lord's question is that the fact that these regulations make no provision for a case such as Mr. Awodola's supports the interpretation of regulation of bylaw 11C, which the judge gave. The fact that the results would be so procedurally unfair, and we say unlawful as a matter of public law, if bylaw 11C were to mean that one looks at this specific step in the procedure and applies the rules in question at the point of that step, the effects would be so unjust that that cannot be what bylaw 11C means, and certainly it seems that's not what the drafters of the regulations understood bylaw 11C to mean, because they give no consideration to the possibility that a case might transition from one set of regulations to the next.
Now, on the last topic, it may be said against you that you haven't got a respondent's notice. Do you want to anticipate that potential submission in relation to the self-standing, independent, procedurally unfair point?
My lady, we say it's all relevant to the interpretation.
Of course, I understand that.
For the reason that I've given, the court's correct. We haven't filed a respondent's notice.
I think we all understand how it's relevant
yes.
to the construction argument, but as a self-standing, separate ground, the judge didn't deal with. There isn't a respondent's notice.
No, my lady. I suspect the only point I can make is that we say she didn't find against us on.
You're right
on
about
that.
Ground. You're right about that.
And so, to that extent, it is an open question, which is so closely linked.
Very well done. Yep.
My learned friend may have something further to offer the court on that point.
Thank you, Ms. McGibbon. You've made all your submissions you want to make?
I believe so. And if
Yes,
I'm not,
thank
I'm
you.
Sure, I'm
Okay.
sure that Mr. Hitchens.
Mr. Hitchens.
That was incredibly discourteous to me, my lady. And I
No,
certainly
no.
didn't cut off
No,
my phone. I apologise. Thought she had finished. My ladies, my lord, can I start, please, with what my Lady Justice Asplin describes as the guillotine point and my lord referred to as the razor point? Because my lord made the point that at the moment there's two stark interpretations. On the one hand, there's the guillotine, as my lady put it, and on the other, there's the indefinite preservation. Now, firstly, my learned friend says, well, the answer to that is an ad hoc discretion. And as my learned friend, Mr. McGibbon, said, we said that in the High Court, that there was an intrinsic discretion in public law bodies to depart from policy and regulations. That in this case, what was actually said on the 18th of February was there's no discretion. We've taken legal advice and we simply can't depart from the rules. And I'll give the court the reference, if I may. I don't think it's necessary to turn up now, but I would invite your ladyships and lordships to refer to this later. So it's C148 of the bundle is what the association said in the High Court, which is that there was simply no discretion at all to apply different procedures.
Sorry, it's Core Bundle 148.
I'm so sorry, it is, my lady, yes. And it's paragraph 53 when you get there. And this is the appellant's skeleton argument before Her Honour.
And that was paragraph.
53, my lady.
Thank you so much.
And I suppose the only thing I'd add to Miss McGibbon's answer to my Lady Justice Carr as to the existence of respondent's notice is actually the procedural regime which you're being presented with today, in my submission, is radically different from the procedural regime that the association presented to the High Court, because now there is this new discretion, which previously was unknown to everybody, that it acts effectively as what my lady's referred to as a sticking plaster. So I simply make the point that if the safeguard is this intrinsic discretion that public bodies have, that certainly was not something that was applied to my client's case, or that the association had in mind when deciding whether or not to grant an oral renewal hearing. My lord, the starkness point that my lord, Lord Justice Snowden referred to, could I posit very briefly a potential alternative answer by inviting the court please to turn up page 109 of the authorities bundle, so A109.
That's the rule book.
This is the 2019 Rulebook, my lady, and it's subparagraph 3 towards the top of the page. And this is regulation 2.3, so it's under the interpretation section. This really goes to my lord's points in terms of the interpretation and how the public law principles interface with the interpretation of the regulations. So what this says very plainly is the Interpretation Act 1978 should apply to these regulations as though they were enactments. Now, the reason that matters is if we go to page 4 of the same bundle of the authorities bundle, so A104, we have section 16 of that act. And it's subsection 1C that I say is the significant one. So, my ladies, my lord, what I say is if my learned friend is right, and the effect of 11C is that the 2019 regulations were in operation, then it isn't the sharp tool, as my learned friend put it, that means all of these provisions shall automatically apply retrospectively. Instead, because the interpretation section of the regulations clearly say you have to look at the Interpretation Act, what the reader has to consider is whether a intention is clear on the face of the regulations for, in this case, the provisions of Regulation 6 to apply retrospectively. Now, I suspect what my learned friend will say about this is I get over the line with Regulation 24. Because there's an implicit, he says, an implicit intention there, that they're the only appeal regulations which will be preserved. My ladies, my lord, I say that plainly isn't an express intention. And the point that arises, and this is why it goes to the sharp tool point, is if it's not express and if it's not absolutely explicit, and there's some debate as to whether or not that does express an intention, in light of the fact that the court is hearing ground 2 and ground 2 has been granted permission, it could be said that there is some degree of question as to whether or not Regulation 24 has that effect, although we say it doesn't for reasons I'll come on to. Then all of the case law that both my learned friend Mr. Ozin identified and my learned friend Ms. McGibbon has addressed you on comes into play. You have the checklist, what is the clarity of the language, what is the unfairness that would be caused, what is the mischief, and you have that interpretation exercise to undertake on every regulation, every year that new regulations come into force. That's why, my ladies, my lords, we say our interpretation of bylaw 11C must be the correct one, because that, in my submission, would cause chaos. It would cause chaos in the context of proceedings which are quasi-judicial and ultimately will determine someone's livelihood and their professional status. Proceedings where both the appellant and the respondent agree there's a need for legal certainty and procedural regularity. So, my lord, I say, I think, I don't know whether it was my lady or my lord said, used the word void. That's what would fill the void. If the respondent's wrong about the interpretation of 11C. Could I move on now to address ground 2 very briefly, my lady? I don't know how much it's helpful to say about this ground. I can address it. I think I'm conscious that my learned friend has a right of reply and I don't want to eat into his time. I think I can address it quite briefly. The first point is, my learned friend said the bylaws are the paramount, the primary set of rules, the constitution of the association. What I say is you cannot use regulations adopted under the bylaws many, many years later as an interpretation aid for bylaws. That simply doesn't work. It would be akin, in my submission, to a minister facing judicial review proceedings on the basis that he's said to have misinterpreted a statute, adopting an order under that statute, and then relying on the contents of the order that he himself had drafted to say, well, no, my interpretation of the statute was correct. It's simply putting it the wrong way around, in my submission. And the second point, so the first point is it doesn't really assist at all with Regulation 24. The second is it's not inconsistent. And really this point's been made by my Lady Carr already, so I won't labour the point. But the point really is this: when one looks, firstly, when one looks at bylaw 11C, which I think is at, it's page 24 of the authorities bundle, my lady. was just saying, in respect of the, for the avoidance of doubt, simply adopt the observations of Mr. My Lord Lord Justice Snowden earlier. There's two limbs in my submission to bylaw 11C. The first relates essentially to the substantive rules of conduct which govern the disciplinary proceedings, the first instance proceedings. Limb 2, so that's the first sentence. Limb 2 relates to any disciplinary proceedings, and it's common ground, I think, that applies both to disciplinary and appeal proceedings. So you're faced with a situation where you have an express saving position for substantive rules at first instance, express provisions dealing with both appeal and first instance proceedings, both first instance and appeal procedural steps and proceedings, and therefore there's a lacuna in my submission dealing with what are the substantive rules which apply on appeal. Because you have the substantive rules for first instance, not for appeal, and the procedural aspects for both. And in my submission, I'm not going to take the court to it, partly because of the time and partly because I know the court's read in a great deal of detail. But the provisions of Regulation 24, I say, simply serve to answer the question, what about the substantive issues on appeal, and bring the substantive provisions in line with the procedural provisions. So it's filling a void left by 11C, and it's not inconsistent. I've necessarily been quite short, my ladies, my lord. Is there anything I can specifically assist on?
No, thank you very much indeed. That's very helpful, Mr. Hitchens. Mr. Ozen?
Lady, briefly, I've got 5 points. My Lord raised the question in the course of learned friend Miss McGibbon's submissions, how do you address other cases, not just Mr. Awodola's, but construction exercise concerning how the law applies to other cases. May I invite the court in due course to have regard to the words of Lord Mustville in the Loffi-Chiffrian case at page, to use the internal pagination, 528 C to D, which makes it plain that the question of fairness with respect to the assessment of a provision which is liable to have a retrospective effect is not limited to the case in question, but how it applies generally. Ms.
Sorry, do we have that authority?
Milady, we do. It is at tab 9 in the authorities bundle.
It's the phosphates case.
Yes.
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 And page 174 using the bundle pagination.
I misheard, thank you.
Learned friend Miss McGibbon made submissions to the effect that if you apply the date of instigation as being the determinant date, you end up in 2018 because that was the date when he got his papers. May I respectfully invite you to have regard to the date of the referral of the case by the assessor to the Disciplinary Committee. It's a formal step in accordance with the disciplinary rules, namely 6, 1 and 3, 6 open brackets 1 and open brackets 3, and there is specific provision to give notice to the registrant under CDR, the disciplinary rules, 9 brackets 1. The letter doing so is in your bundle at the supplemental bundle tab 2, and it sets out the allegations in full. So it is a distinct formal step by which the registrant is informed of the bringing of proceedings against him. And
that's the 10th of October 2017.
The lady, yes. So we would respectfully submit, even if one applies the instigation test, and it isn't a test in the rules or the bylaws, you end up in 2017. We've not sought to cite the authorities, but the court will be aware that from an Article 6.1 perspective, the reasonable time guarantee runs from the date of referral, and there's clear authority to that effect. The GMC in Pembury and High Court and the GMC, a Privy Council case, both 2002 cases. So the instigation test doesn't really help the learned friends with respect. Third point, wasif. May I invite...
Sorry, it does help in the sense that it would still keep them, the point would still arise in terms of right of appeal in 2017.
Well, yes, in that sense, but it doesn't yield a clear answer, which is the essential point that we are seeking to advance.
Your point is it demonstrates, is it, that if you apply the whole proceedings approach of the judge, in fact you go back further than the respondents suggest. You don't go back just to January 2018, you go back to some point in 2017. It just illustrates the point you say of the breadth of the consequence of the judge's decision.
Precisely. And the court has my point that when the learned High Court judge said, well, nobody suggested it was 2017, we all had reasons for not suggesting it, and in fact, actually applying that principle, it should be 2017. So, with respect, she was wrong. The wasif point, this is my third point, short point. It is in fact a good example of how cutting down an oral hearing can have harsh consequences, but nonetheless be lawful. And that is Authorities Bundle 27, tab 27, at page 301. Could I invite the court to have regard, using the internal pagination within the reported case, to page 2797 at letter F.
Page 3, yes.
It's
The paragraph 7.
Milady, yes. And I think Lord Justice Underhill gives the background to the absolute position that no oral hearing is available upon a finding, a certification that the application is totally without merit. And although the court regretted the effect and considered that it may in fact be an undesired and unintended effect, nonetheless there was clear authority that it was the law.
But I don't think, with respect, the possibility that the general removal of an oral right, so a right to an oral hearing, might be unfair to somebody is not this case. I don't think anybody's suggesting that you couldn't, as a general proposition, remove a right of an oral renewal. I think what's really said in this case is, having told Mr. Awodola that he could have one, and indeed he thought he, in accordance with the rules in force when he asked for it, he could. Sorry, when he asked for his permission to appeal, it's then unfair to say to him, actually you can't. I think that's the way it's put. I think it's on the particular fact, it all goes back to that letter of the 30th of November, amongst other things.
Yes.
Yeah. This is dealing with a more general proposition that everybody has a right to an oral hearing.
The learned friends made some general observations in their supplemental skeleton argument, which I appreciate the court may not have considered in depth as yet, which emphasise the fundamental importance of an oral hearing. Yeah. We can all recognise the value of an oral hearing. We're having one at the moment.
Yeah.
But I just make the point that it is not an absolute lawful right.
Right.
Fourth, I thought it may be helpful if I try to address very briefly the Lord's question: how can it be unfair if you signed up on a contractual basis to rules that specify that the rule in place for the time being applies. The first point to make is that the disciplinary decisions of the ACCA are justiciable in England and Wales, and there is clear authority to that effect. I don't think you've cited it. I think there is in fact a decision in Ireland to the effect that its decisions are not justiciable, adopting very much my Lord's analysis in the particular context of the statutory underpinning of its limited public duties in the Republic of Ireland. But in England and Wales, the position is different. And so the ordinary principles of fairness and natural justice apply, and we would respectfully submit that that permits the court, in the exercise of its supervisory jurisdiction, to apply the must-still toolbox to questions of retrospectivity and the assessment of fairness. Nonetheless, we do pray in aid of the point raised by the Lord, and we submit that great weight should be given to the contractual obligation by which a member agrees or indeed undertakes to abide by the regulations in force for the time being in force. And then to address head on, if I may, my Lord's question, what does the judicial review claim attached to? In my respectful submission, ordinarily will attach to a particular decision, as it has done in this case. And it is then open to the court to ask the question.
Quash the decision. That's what would be appeal if, well, that's what was done below.
Below, yes. Finally, my learned friend's submissions on the Interpretation Act. Well, these are new. I don't think there's any notice of them at all. Further, we have addressed them historically, and we respectfully submit that the Interpretation Act plainly does not apply. We have written submissions on that point, so I don't think, unless you wish me to develop them, that I will do. They are in our detailed grounds, paragraph 32.2, and also by way of quite an extensive footnote, that is at tab 13, page 112 of the core bundle. Essentially, the point is that these are changes made by executive action, not by enactment. And anyway, the guiding principles in section 16 and 17 don't help many friends. And indeed, we drew, as a matter of candour, the court's attention to the incorporation of the Interpretation Act. Those are my 5 points.
Thank you very much indeed, and thank you for all your helpful submissions. We will consider our judgments, and they will be dealt with in the usual way. Drafts will be circulated. We would ask you only to deal with typographical errors and any actual errors in relation to the facts, and then if you cannot agree an order in the end, a consequential order, then all submissions in that regard should be short and in writing, and we will make our decision on the papers. No oral hearing.
A topical way to end.
Thank you very much indeed.